Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Okay, let's go to California. Now, you want to see a legit
back to California.
Yeah, back to California. I think you said this a long time ago. It's like California cannot get out of its own way, especially Los Angeles. So we're back to Los Angeles, but here we have a jury verdict, right? And we have a jury that's awarded a former fire chief, I think a 30-year veteran, $4.1 million in damages as a result of a wrongful termination. But, and I don't know why FMLA didn't come up. I'll talk about this after.
I was going to say that it's got FMLA written all over it. I don't see an FMLA allegation in it.
Yeah. So look, the short is this fire chief had taken some time off. This reminds me of the volunteer firefighter who takes a 2-week vacation, comes back from vacation. Everyone's like, oh, where you been? You still a member of the department, right? Those stupid comments. But in any event, he has a medical issue, condition, whatever. He takes time off to address it. He, has a disability or perceived disability, and they constantly berate this guy. For example, I pulled out a couple of your examples. So, for example, the president, I think, of the West Covina Firefighters Association says that he tried to use this whole disability vacation or, away from work to get a better result in the city's union contract. And they target him saying, we're going to vote no confidence in this chief after his medical leave. Right. So they specifically went after him. Now they're not the employer, right? The union isn't the employer. So that one's a little harder. But the city's council member, an individual, Tony Wu, he was apparently endorsed by the union, and he called for the chief's termination as an absentee chief. Man, you cannot do that. And as a council person, okay, now this is the government, right? So he sues under disability discrimination, disability retaliation, whistleblower retaliation, intentional infliction of emotional distress. You can't do this stuff. And I don't have to say that. You don't have to say that. A jury just said it. 4.1 million. The city said, look, we're going. They're normally we're going to appeal. Here you got a very kind of soft shoe. Well, we're going to look at appealable issues and if necessary, appeal. What I presume is going to happen is they'll say, would you take $3 million, right, and save yourself the appeal of losing it all, or $2 million? So now there'll be settlement negotiations. It'll go away, presumably. That was very soft shoe language. But once again, look, if somebody's disabled, if they're a minority, you do not use any of that as a factor. And I was surprised by FMLA being absent from there. That is exactly what FMLA was there for.
Absolutely.
So, and it wouldn't matter that he had a disability, right? The thing with FMLA, it's a medical condition, doesn't have to be a disability. Here, they have to prove disability. So the disability is much harder to prove than a lower standard of FMLA.